This started as a routine guilty plea hearing, but moments later, the judge ordered a drug test in open court. When the results came back positive, everything changed.
Good morning. Are you Michaelin Skinner? Speak up, please. And Mr. Rennick, will your client waive the formal reading of the indictment?
He will, Your Honor.
Give me just a second to get that pulled up. Mr. Skinner, in cause number 25 DCCR 1852, you're charged with the third-degree felony offense of theft of property from November 6th of 2025, and how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I need you to speak up because I can't hear you, and this lady over here has to hear you. Okay, so use your big voice. Use your outside voice instead of your inside voice, okay? Okay. So I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rennick? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year deferred probation. There would be a $1,000 fine, and there would be restitution determined, if any, between now and when we come back for sentencing. And if there is any restitution, you would be required to pay that. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Skinner is not competent?
Not for the test.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today to start that process, and she's sitting at that desk right over there. Okay? We'll see you back at sentencing. Thank you.
Thank you, Your Honor.
Thank you. Ms. Hawkins, are you ready on, let's see, Mr. Spites? Okay. Oh, well. All right, again, you're Devin Spites. And so now that everybody's had an opportunity to visit about the pre-sentence report, Ms. Hawkins, is there anything? Anything you want to add? Sorry. That was
I spoke to Mr. Spice outside. He informed me that he was nervous in his interview, but he is taking full responsibility for what he has led to with that. He has advised me that he understands that he is guilty.
Okay.
I don't really know why he said that other than just nervous.
Okay.
As far as the recommendations, Your Honor, the recommendations due to ISF, Judge Mr. Spice he's not from Jefferson County. He doesn't live in Jefferson County. He does not frequent Jefferson County. And I do want to bring to the court's attention, the only reason we are before you in this court is because the penal code does allow jurisdiction in the counties where a person has stolen goods. So he was pulled over going down I-10, passing through Jefferson County. I think that's important because what his actions did was they did not affect the people of Jefferson County in a direct way. And I think that's something that should be considered in placing someone on community supervision in the community where they are charged with crime. I think it's important that his actions did not occur in Jefferson County in this case. He has a delicate situation right now, Judge. He has 5 children, very, very small. 3 of them are babies or so infants. Additionally, as the PSR shows, he has pending cases in Fort Bend right now. He's going to court on those cases. He's dealing with those. I think having him in ISF is going to create a much more stressful situation for him in providing for his children and dealing with those cases and resolving everything he has going on in supervision is to help the people who enter into it. He's willing to do all the other conditions of community supervision, the drug testing and all that. I think that ISF was recommended partially because of him admitting to marijuana use. He's willing to
If I test you this morning, you gonna have it in your system? Have a seat in the jury box. Let's check you. Then we'll go forward. Okay, let's get it done just to make sure. Thank you, though.
Yes, ma'am.
I appreciate him. That way I have something in my file as well. Mr. Ward, you have Bart Thibodeau,
Yes, ma'am.
2 cases.
Yes, ma'am. Good morning.
Good morning, sir.
How are you?
Good, how are you doing?
Traffic was a little.
Yeah. Where are you coming in from?
Actually, full shirt. So the other side of Keystone.
Oh,
So
okay.
the west
So you got
gate.
the both sides.
Mm-hmm. Super exciting. I was at 6:30 this morning. So.
Oh, wow.
Yeah. Super fun.
Good morning, sir. You're Bart Thibodeau?
Yes, ma'am.
And Mr. Thibodeau is here in cause number 25 DCCR 0339, charged with solicitation of prostitution, and 25 DCCR 0755, charged with possession of a controlled substance. And what is the announcement?
Plead not guilty to those counts.
And let's see, when were you? I'm trying to see
January 8th.
when you were hired. I don't even see it in this file.
Did I have it? Most of this cover.
No, I'm sure you did, but otherwise I wouldn't have you on my docket. I just don't see when it was filed. So what I'll do, Mr. Thibodeau, is reset the cases for about 30 days to give you some time. Get with Ms. Malfino. She'll explain the process to get on the portal, to get all the discovery, and then we'll see where we are at that next court date. All right, make sure you stay in touch with Mr. Ward. He's going to get all the discovery in the case electronically, and then he will, I'm sure, want to get with you and go over all of that before the next court date. All right, you're free to go. Thank you.
I would as far as he did want to amend some bond conditions, I don't know if you guys want to like formal.
Did you file a
No,
motion
I
on
didn't. I
that?
just wanted to see if you wanted to do a docket entry or would you like to follow
I think just to give Ms. Malfino time to see what that is, if y'all want to talk about it real quick before you leave, if there's some agreement, you can let me know. Otherwise, if there's some issue, I'll give her at least a week or so to get ready on that.
I
All right,
completely understand.
just let me know. I'll hold it. Yes, sir. I'll hold it, ma'am. And have we seen Mr. Sean Villery, Samuel? Oh. There it is. Well, he got out to come in to see us. That's not fair. It's very old. Gotcha. Yeah.
Already on Crackle.
Okay.
His dad is going to be up here for the plea. As you know, his dad's been appointed his guardian.
Sure, that's fine.
I feel like he's more than competent to take the plea and everything else, but I just want to cover my
We'll put all
behind.
that on when it's time to.
Okay, I'm just letting you know so I'm not scaring you while
Thank
you
you.
come up here.
Thank you.
So,
Mr. Stringfellow on John Roy. And do you have your discovery certification? Okay, perfect. Thanks. Thank you, Mr. Coleman. Thank you, sir.
I need to email that.
Good morning, sir. Are you John Roy?
Yes, ma'am.
And Mr. Stringfellow, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Roy, in cause number 25, DCCR 1365, you're charged with a state jail felony offense of driving while intoxicated with a child under 15. And that's from July 3rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Stringfellow? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated for 4 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, Mr. Stringfellow. It's admitted. Is there any evidence that Mr. Roy is not competent? All right, Mr. Roy, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report.
A couple of things, Judge. The agreement contemplated an interlock device. I don't know if the paperwork checked out. Another thing, Judge, I don't know if the court would entertain. Mr. Stringfield and I talked about this, maybe waiving if he decides this.
Okay, let me, can you send me that paperwork back, Anna, and I'll write, that's your agreement, is that he would have an auto ignition interlock device on any vehicle he drove? No history that you
Judge,
can...
The state's file reflects a 1994 operating a vehicle by intoxication. That's out of the state of Louisiana. And a couple of arrests, an arrest for battery in 2008, another arrest for battery in 2019. Other than that, no other history. My understanding is that the defendant is from Louisiana?
Yes, he resides in Louisiana.
Okay. So, with everyone's permission first, can I make that right in on that agreed punishment recommendation page, the agreement for the auto ignition interlock device?
No objection.
All right. So then what I'm going to do, Mr. Roy, based on Mr. Coleman's representations with regard to any real lack of criminal history, is waive the pre-sentence report. So again, make that finding that you entered that plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of the state jail felony offense of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that, so you're on probation for 4 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes having the auto ignition interlock device on any vehicle that you drive. You cannot drive a vehicle unless it has that. You'll talk to probation today here in the courtroom. She'll probably send you over to the probation office at some point. It's important you give them all the information of where you live so that they can work on the proper process of getting your probation transferred over where you are, okay? I'm handing you now the trial court certification. That shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney. All right? Good luck to you, sir. Make sure you stop and talk to probation. She might be ready for you now. She might have you have a seat and then visit with you. Yes, sir.
He currently has a portable device. Do you think it's possible for him to keep that device instead of installing the permanent machine into his vehicle?
Mr. Coleman, what's the state's position with regard to the portable?
Not necessarily opposed to that, Judge.
Is it it's not required on the state jail felony for him to have, for me to make a finding on the auto ignition interlock. It's not. Okay, so what I will do is have probation place, if he has the portable, he doesn't have to have the auto ignition. If there's any issues at all with missing portable, if you miss blowing or it's whatever happens with that, number one, it could be a violation of your probation, or it could require maybe having both or whatever it's going to take for me to feel like you're safe out there on the road. But keep doing the portable for now. I'll take away that interlock requirement unless there's some issue that comes up that makes me feel like that would be necessary. All right. Yes, sir. So stop and talk to probation. She'll let you know you probably need to have a seat after that for a few minutes. All right. Thank you, sir. Have a safe trip. Where are you coming? Where'd you? Houston. Be safe getting back. Yeah, and then did we lose Mr. Gertz also?
They went in the back. He's in the back.
Okay, that's fine. Take your time. And so we've got, I'm holding 2 for him, and then Burbanks, and then Buddy. Where's Mr. Reynolds? And I held it, I think, for them to oh, yeah, on Buddy's, on Mr. Reynolds. Did y'all talk about, that was the Deshandra Joseph? Oh, that's right. Yeah. Sorry.
We did talk about it.
Yes,
So
I wrote down the wrong thing. I wrote hold, but I meant to write till tomorrow. Okay, thank you. So I reset Hatcher. Right. Gertz is. Yep. Mr. Gertz, on Shay Morgan, were you able to visit about Miss Morgan's case?
Yes, Judge. I'm gonna ask for. She's sitting right.
Miss Morgan, Shay Morgan, come up, please, ma'am. All right, ma'am, you're Shay Morgan, and Miss Morgan's charged with theft of property and cause number 24 DCCR 2102. Mr. Gertz.
We have an offer for resolution in the case. Ms. Morgan has indicated initially that she wants to go to trial, but she's got a number of things that she wants me to look at in terms of evidence. She wants me to present to the state prior to rejecting the very, I think, reasonable offer that the state is making, or the reasonable option that the state
So
is
here's the
giving us.
thing, Miss Morgan, I'm going to address you on this. Mr. Gertz has been your attorney for over 6 months now. So if there's information that you think is important, you should have been getting that to him 5 months ago. So I'm going to reset the case one more time. This is the last reset. So whatever information you need or get to him or think is important, get that to him so he can get it to Ms. Malfino. And at the next court date, if there's a resolution, great. If not, then we'll get it moved to the trial docket.
Thank you,
Okay?
Judge.
All right, you're free to go. Ms. Hawkins and Ms. Malfino on Devin Spites. All right, so Mr.
In sentencing, timing matters. Actions taken even after a plea can influence the court's trust. And in this case, that trust was clearly tested.